5 minutes past 10, our talkback lawyer David Whiting is here to help you with free legal advice. The number is 1300 222 774. That's the number, 1300 222 774 if you would like some free legal advice from David Whiting. And David, good morning to you.
Good morning, John.
We're free now to talk about something that we've quite deliberately avoided over the last 3 or 4 weeks, which is your candidacy for election to the board of the Royal Automobile Club of Victoria, the RACV. I noticed that ballots closed last Friday. I actually got my voting papers so late that it was impossible to return them within the required time.
I'll accept any excuse, John.
No, I voted for you, but I got my papers on either Tuesday or Wednesday. I'm not sure when they got put in the letterbox. I only found them on Wednesday, which meant it was next to impossible to return them in time, which I thought was a bit substandard, quite frankly. But how did the campaign go?
The campaign went pretty well. I ended up with the system is there were 3 candidates, 2 of whom were board members seeking re-election, plus me, for 2 places. Yep. And what it meant was that every voter got 2 votes. And so to get on, you needed 2/3 of the people who were voting to vote for you. I got 46% of the people were prepared to have me as a director, which I thought was pretty exceptional in the circumstances.
But you fell
short.
First
attempt, I fell short. You needed the 2 voters, the 2 directors standing for re-election were elected. The total number of ballot papers was just over 60,000 in an organisation of 2.2 million people.
So hardly anybody votes.
Yeah, very low participation rate.
That surprises me, I might say. I would have thought more people would participate, but given that they don't, the next question is, you just gave us a hint then, you said first time candidacy. So
one never say never, John. I found the process interesting. Probably the answer would be most of what I did was on Facebook, and I would be suggesting that the answer needs to be outside Facebook. There are other ways to get the number of people that you need to get the vote. So who knows? Let's wait and see.
The information that's sent out tells you next to nothing about the 3 candidates and what they actually do and don't believe.
Then they
stand for.
Well, there's no provision on the document for a policy statement. The answer
that's a bit silly, isn't it? In any election, you want to know why other than it being a popularity contest, you want to know what they stand for. If someone says, I'm running for election for the RACV and my policy is no one should own a car, well, that's fairly relevant. You want to be told that.
The answer is you will answer the following questions. We will verify the answers that you provide. We will put the information in the grid. John, the election papers went out on the 14th and 15th of September. And while I had been...
They most certainly did not go uniformly out on that day.
Well, I have some sympathy for the distributor. There are 2.2 million magazines that need to be delivered. But my frustration is that I was not allowed know. I'd been a candidate since the middle of July. I was not allowed to know until the middle of September, when the papers had been delivered, who the other candidates were.
Yeah, well, it's
never mind.
Well, look,
next time.
Maybe that's a chat we'll have with the RACV, an organisation with whom we enjoy extremely productive relationships and which do a lot of good in the community, but I don't understand why the process of electing people to their board is so complicated and so labyrinthine.
Well, if you consider that for 99% of the people who vote, the only practical way of voting is by mail, and you assume that it takes between 2 and 4 days to get a letter back.
And the rest.
Well, I'm being generous, but 2 to 4 days. You effectively need to make sure that you've got your voting papers out and delivered 10 days before the election closes.
Yeah, but I'm just saying I don't understand. First of all, such low voter turnout in the first place is an issue, and then you're told so little about the candidates, what they do and don't believe in, what their values are, what their...
You're not told anything, John.
Yeah, and that's suboptimal as well.
Well, you'll find it interesting then to see that they're amending their constitution at the annual general meeting in 3 weeks' time to allow for electronic communication with their members, but it doesn't go so far as to allow for electronic elections.
Yeah, well, lots of organisations are wary of that, and I well understand why.
Mm-hmm.
I well understand why, but it's very expensive. Every time you send a letter to the members, it costs you $1 million
or more, John. 2 million people, $2 million.
People, yeah. Well, there's bulk postage, but either way, printing it out having it
Yes.
Professionally printed out, enveloped and addressed. It's an expensive exercise.
Indeed.
There's no doubt about that. All right, and we've got a new Chief Justice sworn in, I think, yesterday, according to the Vice-Regal notes in the newspaper today. So the last
I don't
one...
read them anymore, John.
You don't?
No.
Oh, it's the highlight in the morning.
Oh, okay.
So the Governor of Victoria, Linda Dessau, swore in the new Chief Justice Anne Ferguson to the Supreme Court after the retirement on Friday of Marilyn Warren. So the baton has been passed.
Yes.
So
Excellent.
it's all business as usual up in the courts.
It is indeed. They are busy.
Yep. Anything else?
There's a couple of things, John. We talked a little while ago about an inquiry that was to be undertaken in relation to the effectiveness of the family court and whether there might be alternatives. We're currently, they are currently considering a pilot dispute resolution project involving parties appearing before multidisciplinary panels without legal representation, and it includes psychologists, social workers, paediatricians, drug and alcohol specialists as among the people who would be sitting on the panels. So there's that one. I've normally gone to the Premier's website, premier.vic.gov.au, to look and see what announcements are being made. And I saw last week that there were a series of proposals in relation to changes to residential tenancies, which made it to the Minister for Consumer Affairs website, but didn't make it for some reason to the Premier's website.
Certainly made it to the Northcote by-election announcements, where there's a very high proportion of renters in that electorate.
So a crackdown, these are proposals are correct, crackdown on rental billing.
Yep.
A rental bidding, and there's a lot of that, in an area that's considered desirable. The answer is in that you have an auction for a house, you have an auction to rent a house.
Yep.
A single price, and you'll not be able to solicit rental bids. Changes in relation to having pets, faster tenant reimbursement.
So they want to reverse the onus so that it's default. You can have a pet unless there's a reason not to, rather than the other way round.
Well, yes, but the press release was quite strange because it said you still needed the landlord's consent, but the landlord can only refuse on certain grounds.
So the standard tenancy agreement will probably be amended to make it, well, unless there's a reason not to have pets, then pets are okay, but you'll probably be asked to pay a premium for them.
Well,
landlords will say, yeah, I don't mind if you're having a pet, it's an extra $10 a week because I'm going to have to, they're going to scratch the paint near the doors and all this sort of stuff.
Except then that flies in face of the requirement that there be a single price quoted for rent.
Okay.
So, again, let's wait and see what the legislation says. Sometimes it's not always the same as you see it.
All right. And something flashed through my mind. Text messages galore saying we only got our voting papers on Friday or even 2 days ago. So today being Tuesday, they would have got them, 2 days ago to get post-delivered on the weekend. I don't think so. But there's half a dozen text messages from people saying they got their ballot papers even on Friday.
Well, I got phone calls from Port Fairy, Ocean Grove, Newtown in Geelong, Frankston South, Doncaster, Thornbury and Northcote. So,
saying...
Sorry, don't have time to vote, just got it.
Only got, too late to return them in time?
Basically, from Tuesday onwards, I got those calls.
Well, maybe we'll put in some calls to the RACV about how that works, because that's not how it should be. 1300 222 774. Let's get to your calls with David Whiting and Bill in, is it Diamond Creek, Bill?
That's right, John, David.
Welcome.
I recently purchased a property in a rural area, and it's served by a town water supply, and also it's got its own tank and tank supply off the roof with a pump that pumps the water into the house when you turn the tap on. I went with the agent for a pre-settlement inspection, and when we walked around the place, I looked in the little lean-to that the pump is attached to the side of the house, and the pump was there. Then settlement took place, and on the day of settlement, I went to the house and opened it up, and they'd turned all the lights on and everything. I turned the tap on, and there was no water. So I had a look around the place, and I found that the pump, the tank water pump, had been removed, and the valve into it had been shut off, so the water didn't flow everywhere.
Yes.
Thanks. Now, where do I? It was. I discovered this after settlement, I'd paid my money and I'd done everything as far as I knew.
Bill, we have a distinction at law between what we call real property or land and chattels.
Yes.
And chattels are the things like the dishwasher and in some cases the TV antenna. There are lots of things which are affixed to the land for the purpose of them being utilised but don't form part of the land. So, and what happens is when you sign the contract of sale, you buy the land and you buy the chattels that are listed, but you don't buy any chattels that are not listed. So my guess would be that the water pump, it's clearly a chattel, would not have been listed.
Okay. It's got an external hot water system that sits outside the house too. Could they have removed that?
If it wasn't listed, the answer would be yes, they probably could.
So there's a cautionary tale here for purchasers to make sure that they...
Can I say, Bill, there are two cautionary tales for purchasers. The first one is to make sure that you've listed every chattel that you see and you think is passing with the property.
So it's in the documents for the contract of sale.
Underneath in the contract of sale, you're buying the property and the following chattels.
Yep.
So I see people who say, no, I want the chandelier out of the front hallway, right? And
in which case, the agent saying, yeah, no problems, you can have it, is not good enough.
No, you want it included or excluded, as the case may be.
In writing, in the contract, absolutely there.
So, I mean, I can remember, John, you and I have had a discussion about people taking light fittings and light switches and other bits and pieces.
PowerPoints. I did a conveyance once and the people came to the house and there were wires sticking out of the wall.
So, the question is what's a chattel and what's a fixture, what's part of the land. The other salutary lesson, Bill, is if you're going to make an offer on the house, test that everything works. It's the number of things that don't work, but you don't test them when you're inspecting. So I have a friend a cousin who bought a house with an air conditioning unit, and the air conditioning unit was... When they moved into the house and they turned on the air conditioner because we had a hot day, it wasn't working. And we were told by the vendor solicitor after settlement, well, no, it hasn't worked for 15 years. But it was listed as a chattel in the contract of sale. As
an air conditioner, not as a working air conditioner, just silly. An air conditioner.
Yeah.
I know. So, right. Bill?
So, Bill, they're the two lessons. Make sure they're listed for your next property. Make sure they're listed and make sure they're working.
Okay. Thanks a lot, Dave. Thank you.
And look, I hope that's educative to everybody who's tuned in this morning, David, because it's an assumption a lot of people make. Oh, yeah, that must be part of it.
Well, normal practice would be to ask the purchaser, the vendor, to confirm what's listed. And see, there are conventions in the societies in which you live in. As I understand it, in America, you always leave the stove. You always leave the fridge, because fridges are often built in. But I also know that in Netherlands, where
but fridges aren't. Well, that's if they're if they're plumbed in.
No, I still reckon it's
sort
of
fancy ice maker stuff.
The only purpose for doing that is to make sure the ice maker works.
Right.
But in places like the Netherlands, you take the stove. Now we always leave the stove. So it's what are the local rules and how do we embody them?
Yeah, you don't take the sink or the taps.
No.
So okay, but if you're in doubt. And it's not good enough for the estate agent just to say, oh, yeah, that's included. You don't want to have to rely on that when you've already paid over your money and something's not there that you thought should be there.
Absolutely.
Ian in Warrnambool. Hi, Ian. You're through to David.
Hello, Ian.
Hello, Alan. Basically, my parents in England,
yes,
I'm originally from the UK, were taken into care and in 2016, October. And I got the family lawyer involved.
Yes.
The lawyer where their wills are with, about getting power of attorney for me.
Yes.
And he deemed them not able to do that because of their dementia.
So they're not capable of giving the power of attorney. Yep.
Yeah. And we have just received an email, right, with no... consent from us and no emails, phone calls, nothing, but now he has the power of attorney and is going for deputy.
So what he's done is he's made an application to the Court of Protection?
Yes.
All right, so he's not going to be the attorney, but he'll be what we call an administrator.
Okay.
and that he's the person. Do you think someone over there could do it better?
Well, the thing is, we've had no consultation, we've had no emails, no phone calls from him, and we received a phone call from the care home because they were a little bit upset with what was going on. And
so, who's the alternate, Bill? Ian? Who's it going to be if it's not the lawyer?
Well, the thing is, I can't be seemingly deputy because I'm here.
Yes.
But when he went to get power of attorney for me, they were deemed that they couldn't do that. He deemed that.
No. Well, I think there will be. I don't think he will have a power of attorney. I think he will.
He's got power of attorney.
Well, I do think then you've got to look at this in terms of your end solution, Ian.
Yes.
So one of the things that you need to say, well, if it's not to be him, who is it to be?
Okay. Now, is there possibly a body that I can go to?
Well, I do know that the issue will be resolved by the Court of Protection.
Court of Protection, yeah.
And why don't you Google or web search the Court of Protection? My assumption will be that there will be a legal aid body who will be able to assist you.
Okay.
But it may be also that you could attend the hearings of the Court of Protection by telephone.
Oh, okay.
Or can you do it by Skype or by FaceTime or something these days?
Yeah, probably Skype rather than FaceTime.
Okay.
Well, not because I've got a prejudice against one
it sounds like
software. Was it Skype is now Microsoft? So okay, it's more that I can't see the member holding up their phone.
No. They all do the same thing.
Yeah.
They all do the same thing. Okay, so look,
can you
Ian,
multi-broadcast on FaceTime?
Yeah, you can.
Okay,
and we have on FaceTime Live.
Okay.
Facebook Live or FaceTime and Skype, we can do all of those things and sometimes do.
Ian, Court of Protection, have a look,
yeah.
and the answer might be you simply need another lawyer, but you have to think the next step. If it's not them, who?
So you can put a proposal to them. Text messages, LED light windows removed after sale, replaced with ordinary glass.
Yes.
Says D.
There's also a lot to be said for taking a whole lot of photographs.
Yeah.
When the moment you make the offer.
Yeah. And in Romania, the practice is to take the kitchen sink, the tap, even the cupboards. And it's like being a tenant, says Glenda from Warrnambool. Go over and have a condition report and note every tiny blemish. And any number of people, and I must say that this is quite remarkable now, people saying that their RACV ballot papers arrived yesterday. And there's at least a half a dozen of those.
Okay.
And people saying, I never got mine, and someone else saying we have 3 memberships in our household, but we only get 1 magazine, thus 1 ballot paper. So there's an issue there as well.
My other complaint was that there are 30,000 club members, 2.2 million service members. All of the club members got theirs early. So anyway, wait and see.
Lynn in Sunbury, good morning to you.
How are you, John?
Good and welcome.
Thank you. My query is, my daughter was in a long partnership with her partner. They had a baby recently. At 4 weeks old, Dad decided this was all too hard. He's a New Zealander, and from all intents and purposes, he has moved most of their funds, a considerable amount, being to New Zealand. How does is there any way my daughter can get any of this back? Where do we go?
Where is the son-in-law or your daughter's partner?
Well, he's still in Western Australia, but the money has moved to New Zealand.
Okay. Just so we know what sort of volumes we're talking about, Lynn, are we talking?
About 300,000.
A lot of money, okay?
Yeah.
Lynn, the process would be Western Australia runs when they set up the family law jurisdictions, they offered each state the opportunity to run their own courts.
Yes.
Western Australia was the only state that said yes, thank you.
Yeah.
So there is a Family Court of Western Australia.
Yes.
So it's an application to the Family Court of Western Australia compelling him to return the money. Now, if you issue the proceedings and serve them while he's in the jurisdiction, then the court will take jurisdiction. What you really want is the order that the money be returned to Australia, and there might need to be paid into court. There might be all sorts of things.
Yeah.
Now, if you know where the money is, it might also be possible to serve a copy of the application on the bank or financial institution in New Zealand that has the money with a request that it be stayed. Now, if it's with one of the major banks...
Yeah, I believe it's Westpac.
Well, if it's Westpac,
I don't know what it is in New Zealand, but
but if it's a major bank here and they control the subsidiary in New Zealand, or an operating arm in New Zealand, you should be able to get an order that stops them moving the money as well.
Okay.
All right.
So it's not that difficult then.
Well, you've got to persuade the judge that it ought to be done.
Yes.
So it's a two-step process: freeze it.
Yeah.
And having frozen it, then have an argument about where it ought to be parked.
Okay, all right.
But Family Court of Western Australia.
Family Court of Western Australia. Okay, thank you
Lynn.
ever so much. Thank you.
Good luck to your son. Mark in Epping. Hiya, Mark. Good morning.
Yeah, good morning, John. Good morning, David. David, just a quick question. I'm suing my ex-boss through the Federal Circuit Court of Australia for unpaid wages. We had a hearing in August, and he was given a court order to pay me within a period of 2 months. He made a partial payment, but then failed to make any further payments. Last week we went back to court, or I went back to court. He failed to turn up. Now the judge has given me an enforcement order, or to seize his assets.
Yes.
In the meantime, the ex-boss has offered me a deed of settlement on the condition that I cancel the legal action.
Is he paying you in full?
No, it's in instalments.
Well,
he's offered to pay me in instalments.
I would be reluctant to... How long is your enforcement order valid for?
I'm not sure. We only went to court on Tuesday. On Friday of last week. So,
Mark, I wouldn't be. I mean, what you might do is refrain from enforcing the order until he's paid you what he owes you. But
he's asking for 8 months to pay me.
Yeah, I think you'll find that the enforcement order will last for a while.
Okay.
Is that finalise the matter?
Yes, the judge...
what's happened is your employer's been ordered to pay you X dollars, and that finishes your matter.
Pretty much, yes.
So why would you not agree that provided he makes these instalments on these times, you'll not enforce the order?
Because when he had the court order, which instructed him to make weekly payments over a period of 8 weeks, he didn't make any.
Well, that's why you wouldn't give up the order.
Yeah, that's what I'm thinking. I don't want to give it up because I don't trust him. Yep.
Then don't. Tell him, however, that you won't. You let it sit there.
It just sits there in the background in case you need to return to it.
It's a court judgment, Mark.
Okay.
That declaration.
There's no time limit within reason?
Well, I think it's 15 years on a judgment, but let's not run it out that far.
Sure.
The answer would be if you make the instalment. While you're making the instalments under your offer, I won't enforce the order.
Yeah, it'll just sit there in the background in case things go wrong and I need it.
Now, his problem, Mark, will be that will be an order that will affect his credit rating.
Mm-hmm.
And that will be and at the end of that time, you might be prepared to say to the credit reporting agencies that it's been paid in full, but in a sense, it's his price for not having met the first arrangement.
Sure. Are deeds legally binding?
Deeds are legally binding, but it's what you've done is to enforce it, you go along to court to get an order that reflects the obligations under the deed.
The fact that it's legally binding is one thing, whether it's enforceable realistically is another.
So I would not be giving up your order without payment. Thank you, Mark.
Good luck with that. In Sydney, joining us is Sean. Good morning to you, Sean.
Hello, John.
Welcome. Which part of Sydney are you in?
Pimble.
Welcome from Pimble.
Yeah, I did major building work in a house, and I got scammed by my builder accidentally. His payment system got scammed, and I got an email saying, pay this money to this account rather than this account. And
yes.
I willingly gave this other account $30,000. It was the same account I used, same branch, same bank that I used.
Yes.
Reported the police the day after, reported the bank straight away. I knew it had happened. So they didn't want to help. The bank said, well, we'll write to the owner of the account and say, can you give us the money back? Obviously,
yes.
They didn't. It was all fraudulent.
Have you spoken to the Financial Services Ombudsman?
Yeah, but they don't want to. They're not very helpful because they just go back to what the bank says. It's all privacy. You gave them the money willingly, therefore we can't help.
So, sorry. I had exactly the same problem, Sean. It ultimately got resolved with the assistance of the bank in my case. Sean, right. You have the right to sue the bank. And
right.
what you're doing...
How do I do that?
Well, sorry. You sue the bank in how much money we're talking about?
$30,000.
Probably the magistrates' court or the local court in New South Wales.
Right. And the policeman has told me the money is there. They've checked the account and they can see the money, and the account hasn't had any activity. I think the bank's probably
frozen
the account.
Okay, there is a process, and it may not be in the local court, but it will be in the district court for what's called pre-trial discovery.
Yep.
So you can use that process to find the identity of the people who own the account. All right. Now, what amazes me is that the police are doing absolutely nothing. I suppose, though, there's really no offence being committed until somebody
No, because I gave them the money. I gave them the money.
But
that's
there's no... Yeah, I know, but if you... It's almost like, it's not quite, but it's theft by finding. You know, I find something that clearly belongs to someone else, and I make no effort to find out who it belongs to.
Yeah.
But if the money's in a frozen account, you're halfway there, aren't you?
That's my feeling.
So you need to force the bank the whole way.
Something.
And David's advice is that by
there is a process
showing
in the court.
them that you've got some steel in you and going to court brings it into the bank's legal department and perhaps gets it the whole way.
The local court?
Well, each set of courts, you run the local, the district and the Supreme. You need to look at the rules of court about what's called discovery from a non-party. And it's a process whereby you say to someone, you've got some information that can help me identify someone I'm entitled to claim money against, tell me who they are. And that's the process you follow.
All right, I hope that helps, David. Can we impose on you for one or two more after the news headlines? Brenda in Newport waiting patiently to speak to David. Good morning to you, Brenda.
Good morning, gentlemen. Thanks for taking my call. I have a question that is related to family law, and it's on behalf of someone else. My son has been in a vexatious and difficult, protracted separation from his partner, and has spent now around $50,000 for his representation by a family law company.
Yes.
His partner has spent zero because she's been represented all along by legal aid. I was wondering, this matter still hasn't been resolved, and there's another court case for sometime next year. I was wondering, I thought I heard David say maybe a week or two ago that if you turn up at court and you are unrepresented, that you will be given representation on the day. And I also wonder then if in my son's case, whether that would in fact be a wise move, because what seems to be left to sort out is really a parenting agreement that is in place but doesn't have a court order because the court found that the mother won't know where she is going to be because the house hasn't yet been sold. She's currently living in the home. And so they weren't able to make final orders around the children, although these orders have been these arrangements have been in place for 2 years now. He has 50%.
Brenda, let's deal with the first bit first.
Thank you.
If you are attending at a magistrate's court in a criminal matter and you want some assistance to give what's called a plea, and that is in circumstances where you are admitting the elements of the offence, and really what you're doing is you're throwing yourself on the mercy of the court in terms of penalty. In those circumstances, most courts either have legal aid lawyers or volunteers who can assist you. So that's local, most magistrates' courts. Mm-hmm. If you're running a plea of not guilty, then you will fill out an application for legal aid, and the matter would not be dealt with that day, and you may or may not get legal aid. I do not believe that there is the same system in place for family law matters. And I also think that to expect that the lawyer your son would hope to engage under that arrangement would be in a position to get on top of all of the issues and adequately represent your son in an hour.
And something as important as
I understand all of that, but it just seems
it is possible, Brenda.
2 years,
it is possible for your son.
Not one single point. I think the climate, the social climate, may be certainly contributing to that. But yes, it doesn't seem like value for money, if you like.
No. Well, if it's in a sense, it's like I can't promise the outcome. I can only promise the process.
Yes, and the process is long and difficult.
That's why the federal government is running a parliamentary inquiry into process. It's why they're looking at alternative methods. I mean, a few weeks ago I said that there was it's reported that judges in the Parramatta Registry of the Family Court had caseloads of up to 600 cases each.
Which is preposterous.
Well, you can't do justice to any of them. It's hard enough keeping them juggling, Brenda.
And there was also a story during the week about a young couple who'd only been married a short time who spent $200,000 arguing over a $60,000 car. Did you read that one?
Yes, I did, and he ended up with 4% of it on the basis that most of the value of the car had been paid for by her parents.
He represented himself.
Yes.
She spent $200,000 on lawyers.
Yeah, she said about 160. He said about 60 because he at the end he represented himself, but prior to that he was like Brenda's son.
And they fought it out in front of a judge, and the taxpayers, of course, paid the costs of the court, which is completely unreasonable. And at some point, someone should have said to them, "No, we're not going to do this. You're not going to do this, and we're not going to indulge you with days and days of ripping into each other at the public's expense."
Brenda, it's possible for your son to consider being a self-represented litigant?
Has worked in the past 18 months, but she's just had a baby, not his.
Brenda, your son has the right to be a self-represented litigant should he wish to be.
Right, so in the family court...
Any jurisdiction at all, you can be a self-represented litigant. But the best investment...
Then result in him being given some assistance should he turn up at any time?
In sense of representation, absolutely not. Right? There is no one sitting there to help. I mean, if I was sitting in the family court and you were saying, I wouldn't know what to do. No. I would not know the 2-year history. I couldn't negotiate.
And it's an unequal battle. But judges do what they can to help unrepresented litigants, to the point where judges now say, look, we can't cope with the obligations we have to make sure that a contest between a represented person and an unrepresented person is a bit fairer, and that's why the crisis in legal aid needs to be addressed.
So she has been represented by legal aid all along.
And if both parties are eligible, then they should be too. Brenda, there's only so much. Brenda, you're not listening to us.
Go on, sorry.
There's only so much David can help you with on the radio.
Yes.
Brenda, I would be spending... Your son's got a lawyer who understands... Your son's been to court, he's got a lawyer who understands where the matter is at. I would be spending another 3 or 4 hours with that lawyer to get a proper understanding of what, when and how to represent himself in the proceedings. And the only issue that really becomes irrelevant at this point is what he might expect in terms of outcome and how far away he is from it. Thank you, Brenda.
Good luck, Brenda. And last one, Barbara in Mornington. Hello, Barbara. You're through to David.
Good morning, John.
Hello, Barbara.
Good morning, David. Hello, can you hear me?
We can. But we can.
Oh, good.
Yep.
In July, I got a quote for some landscaping, and it was for $6,000. I paid foolishly in a senior's moment half of that for materials.
Yes.
And the work was to begin about 2 weeks later, and the person rang on the night before claiming a death of a friend, so he couldn't come. And I took that, and we made another arrangement about 2 weeks later for him to return. And again, he messaged me to say that he had the flu and that he would continue. By this time, I was not feeling comfortable with the whole arrangement. And
Barbara, do you know where he is?
Yes, I do.
And when you had the initial quote, was there a completion date given to you?
Yes.
And are we over that completion date?
Oh, well and truly, yes.
So why would you not say to him... And how many days' work is it, Brenda?
I got his number through.
Barbara, we're losing you. Are you still near the phone? Because we can't hear you. We can't hear you at all, Barbara. I don't know what's gone on. So Barbara's phone's failing on us just when we needed to know the answers to some of those questions.
So everything's out of time. What I would be doing... Well, the principle is that, the contract's been varied as we've gone along. We need to resolve it reasonably.
So a contractual dispute where one party hasn't performed, what does Barbara do?
What I would do with Barbara, if there's 3 or 4 days' work involved in the task, then you will say, I will give you 14 days to finish it. Otherwise,
in writing?
In writing.
So write a letter to them and say, we made an agreement
that you would do this work by this date.
For this much money.
Yeah.
Yep.
You haven't, and I've paid you $3,000. If the work is not completed in a period of, call it 14 days, because I don't know how much work is involved in Barbara's case, then I will consider the contract at an end and I will require my $3,000 back, failing which I'll take you to VCAT and get an order.
Okay, and then the work either gets done, hopefully to satisfaction and the balance is paid, or the $3,000 is the subject of a VCAT dispute. I hope that helps you, Barbara, and I hope you were able to hear even though your phone seemed to vanish on us at just the crucial moment.
Thank you, John.
David, thank you indeed, and look forward to seeing you at the same time at 10 o'clock next week.
Indeed.
David Whiting, our talkback lawyer, helping you with free legal advice each Tuesday after the 10 o'clock news.